everyone, a very good evening to everyone. I hope you all are fine and doing well. So in today's class, we are going to learn some case studies. As you know that this series is completely dedicated to our case studies. A very good evening. So today we are going to start. Already we have done some LC's case studies and the numericals related to the forex business. Now today let's start with this case study where first the background is given, like bank A is there. Bank A which basically issues a letter of credit on 1st of uh, October 2021 in favor of Global Traders Limited UK. Some of the key terms of the LC is given here, like last term of the shipment given, last date of negotiation is given. Now the Global Traders Limited ships the goods on this date 30th of September 2021, just one day before the LC issuance, and presents some of the documents Bank B on 5 October 2021. The documents include commercial invoice, inspection certificate, bill of lading. Bank B forwards the document to Bank A for the payment, and Bank A rejects the document stating that documents are dated prior to the date of issuance of LC, so these are not valid document. But Bank B claims this rejection is not valid under UCP DC 600. So the conflict is there now. Now in that case, the question is there for the students, like, is the issuing bank is basically justified in rejecting the documents because they are dated before the LC date, or what the article 14 subsection I of UCP DC 600 state about the date of documents. And third question is, they are saying about, is if the LC is silent about the date of documents, what should the issuing bank do? And should A, owner the claim for Bank B, explain the reference to the UCP DC rules? So starting with the answer 1, is the issuing bank justified in rejecting the documents because they are dated before the LC? So no. The answer is that no, the rejection by bank is not valid under the UCP DC 600, not valid, right? No, these are not the questions of the risk management exam. In risk management exam, no LC concept is there. I will tell you about the when the risk management portion will start. I will inform you, then you can join from that day, because this is not a part of the risk management exam. Okay. Okay. So the next question they are asking about the, what does Article 14I subsection I of UCPDC states about the date of the documents? See, Article 31. Article 31 is saying about the partial shipment, right? And when the presentation consists one set of transport documents that are evidencing the things, or according to the article 14 subsection I, if I say this, UCPDC provides that there is a document that may be dated prior to the issuance date of the credit, but must not be dated later than the date of presentation. So unless the LC specifically prohibits documents dated before the LC date, there is no disparity under the UCP DC 600. Clear? So this is our second question answer. Third is saying if the LC is silent about the date of documents, what should the issuing bank do? If the LC is silent about the documents or date of the documents, yes, yes. You can exit because these are not for risk management exam. When the module B starts, then we can say that these questions are related to the risk management. Okay. So, third question is saying this: the LC is silent about the document dates. If the LC does not specify any type of restrictions on the document dates, the bank have to follow the UCPDC 600 rules, right? UCPDC 600 rules. So documents that are dated before the LC date are acceptable as long as they otherwise comply or they are following the rules and regulations of the LC terms and are presented with the presentation period. Now, should Bank A honor the claim for Bank B? Explain with the reference to the UCPDC rules. See, Bank A honor the claim. Yes, because Bank A have to honor the clause because the shipment was made between the made before the last shipment date. Right. That is 15th of 10 2021. Right. So in that case, documents were presented within the negotiation period. Documents are not dated later than the date of presentation. So obviously there is no explicit LC term which prohibiting the documents. Okay. Uh, Dated before the LC issuance. Okay, so under the UCPDC 600 rules, LC is completely independent of the underlying sales contract. The focus is on compliance, like follow the rules which are related with the LC and basically the UCPDC rules. So the scenario helps the students to understand how to interpret UCPDC articles correctly. What is the importance of precise LC wording? There is a separation principle in the documentary credits as well as the risk of wrongful rejection and how it impacts the trade or trust in the trade finance, we can say that. So I hope now it is understandable, like this thing is not valid. And what is Article 14 subsection I say is LC is telling about the date of the documents. So what happened in that case? What rules they have to follow? Clear? Okay. Okay. There is a ABC Garments Limited in India. Exports 1,000 cartoons, that is 15,000 shirts, to Dubai Fashions Limited, which is in UAE, under a LC issued by the Gulf Bank. Gulf Bank is the bank of Dubai Fashions Limited. Shipment is done 100 cartoons from Chennai port to the Dubai port. Partial shipment is not allowed here. And latest shipment date is 21st of April May 2021. So the shipment details are given here, like 500 cartoons handed to the shipment company on 15th of 5th month and then remaining on the 18th. First bill of lading issued of 500 cartoon. Second bill of lading issued for 500 cartoons on 19th date. Both shipments, both the consignment shipped together on the same vessel, like that are sailing on 21st of 5th of 2021. Okay, there is a company in the ABC Limited in the India sends the shipment to the uh, Dubai Fashions Limited, and shipment details are there. But both the cartoons, both the vessels are shipped on one date, that is 21st of May 2021. Now in that case, the documents, which are documents are presented? Two bills of lading which covers all the full shipment details, like same port of loading and also the discharge. Same vessel, same journey. Gulf Bank rejects the documents. Why? Because there are two bill of lading. The shipment is partial, which is not allowed. Here they mentioned partial shipment is not allowed and they ready two bill of lading. ABC Limited argues that their presentation is valid under the UCPDC 600 Article 31. So now what happened? The questions are given. Is the rejection by the issuing bank valid under UCP 600? What does Article 31 of UCPDC 600 say about the partial shipments? Does using two bill of lading automatically make this partial shipment? Should the issuing bank honor the payment? Explain your answer. So let's start with the first question. Is this rejection is valid or not? See, here the rejection is not valid. Not valid according to the rules of UCP 600. So the answer is this, not valid. Okay, according to the rules of UCP 600. What does Article 31 of UCPDC 600 say about the partial shipments? See, here basically UCP DC Article 600 is saying, if any presentation consists more than one set of transport document evidencing that shipment is there on the same means and in the same journey, is not considered as a partial shipment, even if the transport documents indicates different dates of shipment. So multiple BLs, multiple bill of lading means that does not mean they are partial shipment. If all the goods are sent on the same vessel for the same journey between the same ports. So this is the Article 31 states in the UCP 600. So according to the Article 31, the thing that this shipment is not partial completely. Correct. Does using two bills of lading automatically make this a partial shipment? See, the documents which are fully comply uh, or I can say that the use of two bills of lading does not make this a partial shipment. Both sets of the goods form a single shipment because they are shipped together, same vessel, same route. Okay. Should the issuing bank honor the payment? Obviously, that documents are fully according to the Article 31 of UCP 600. LC does not specifically requires, LC is not saying that they need only one bill of lading. Since they only mentioned that only partial shipments are not allowed, which means goods must not be shipped in separate vessels or separate journeys, but they are shipped together on one vessel, so there is no partial shipment. In that case, issuing bank, they have to accept the documents. They have to accept the documents. Then they have to honor the payment. They have to honor the payment. They have to release the goods to the buyer or act on the applicant further instructions. Failure to pay would mean the bank is wrongfully dishonoring the LC, which damages obviously its reputation, credibility, and legal claims are there. So multiple bill of lading does not mean there are partial shipment. If the vessel is same, journey is same, ports are same. Correct? I hope that this case of study is clear. Now this rule is understandable. Okay. Now let's move to the next one. I hope that you are enjoying. I know uh, these case studies is little bit looking like you know confusing, but no worries. If this will help you, that is a great point. Okay. There is a bank A that issues LC in the favor of XYZ Exports Limited. Negotiating bank is there, Bank B. Applicant is ABC Imports Limited. Facts are there that documents are presented on this day. Issuing bank completes all the checking and consults the applicant by Thursday. Applicant raises a dispensary on like a problem issue on 14th of March 2021 that BL not marked on board. Now issuing bank sends the swift message of refusal to the negotiating bank on 15th of March 2021. So you can see a little mark creates problem. So calendar is saying 11th Saturday holiday, 12th Sunday weekly holiday, 13th Monday public holiday. That is holy. So negotiating claims the refusal is late under the Article 16D. Negotiating bank is saying that claim is not on time, or according to the Article 16 subsection D, refuses the claim. So what does Article 16D of UCP 600, UCPDC 600 say about the time limit for giving notice of refusal? Was the issuing bank refusal within the time limit under the UCPDC? Was the negotiating bank correct in rejecting the refusal? Who bears the risk if the refusal was not given in time? So basically, if I say about the answer of this question, let's starting with our first question. Here UCP 600 Article 16D is saying this issuing bank must give notice of refusal by telecommunication, by mobile or other means that no later than the close of the fifth banking day. So banks have usually 5 banking days, which excludes the weekends and local holidays, to examine the documents and giving the notice of refusal. Okay. So this is Article 16D saying. Was the issuing bank refusal within the time limit under the UCPDC? So let's check. See, here documents are received according to the question on 7th of March 2021. So if we count 5 banking business day, 7th is 0 day, 8th is day 1, 9th is day 2, 10 is day 3, 11 is Saturday, non-working day, not counted, 12th not working, not counted, holy, not counted. So 14th, now that means day 4, 15th is day 5. So 15th was the 5th banking day. So refusal was given on the basically within the time limit. Okay, refusal is there within the time limit. Was the negotiating bank correct in rejecting the refusal? No. Negotiating bank incorrectly claimed the notice was late. The refusal was valid, which is given within 5 banking days as per the UCP DC. Who bears the risk? If the issuing bank failed to give the notice in time, then the issuing bank lose the right to claim, and any discrepancies would be obliged to owner reimburse as per the LC terms, even if the documents are not valid. Even documents are not valid in that case also. Issuing bank is not having the responsibility, is not able to do the things, to claim the things, or to make the things okay, right? So here, always count only banking days, public holidays, Saturdays, Sundays. Don't count if the bank is closed. The issuing bank here have to act promptly once the 5 days are over. The bank deals are in the documents, not in the goods, but they have to strictly comply with the UCBDC timelines to avoid automatic acceptance of potentially different documents. Got it? So this is the case study. I hope that you understand the things. Okay. Here, Bank A negotiates the documents under the LC. Okay. Bank A is there which negotiates the documents under an LC that calls for insurance cover, like warehouse to warehouse, minimum 100% of the invoice value. Okay. Invoice value is US dollar 17,920. Multi-modal transport documents, combined bill of date is this. Insurance policy is this, dated on this date. Bank A sends these documents to the issuing bank for payment under the LC. Does the insurance policy meet the coverage requirements of Article 28? Is the date of insurance policy acceptable under the UCP DC 600? Or what disparity does the issuing bank have the right to raise in this scenario? What should happen if the insurance is dated after the transport document date? What should you advise the beneficiary to do differently next time? So let's see the questions one by one. Okay. So here, first question. Does the insurance policy meets the coverage requirement? Invoice value is given. Required coverage is 110%, which is obviously we calculate the 110%. So it is equals to 19712. But here insurance provided of about this amount. So coverage is sufficient here. So it exceeds the 110% as required by the Article 28. So it is okay. Is this date is acceptable? No. Why? Because Article 28 clearly says that the date of insurance document must be not later than the date of shipment, unless it appears from the insurance document that the cover is effective from a date not later than the date of shipment. So here you can see the bill of lading date and insurance policy date are different. Insurance policy date is 2 days later than the transport document with no evidence is there. So here the date is not acceptable. Who is having the right to reject? Issuing bank. Issuing bank has the right to reject the documents. Why? Because the following documents, the insurance document is dated later than the date of transport document. There is no statement that the cover was effective from the date of shipment. So it is not complying the LC terms under the Article 28. What should happen if the insurance is dated after the transport document date? I think if the insurance is dated after the shipment date and does not show the coverage, so issuing bank is there entitled to refuse the payment under the LC. So here issuing bank is responsible for this thing. And what is the basically, if this insurance is dated after the shipment and does not show coverage which is starting from before on the shipment date, the issuing bank must treat it as a issue, right? And what is the practical advice here for the next time? Always ensure the insurance document is dated on the same day or earlier than the shipment date, or it clearly states cover starts from the shipment date or before. So double check all the LC terms, especially for the coverage, and always comply the rules of the LC term. Got it? Okay, let's see this one for today. Just go through with these, so it will help you out. Okay, so there is a branch. You opened a branch and import letter of credit with the following terms. Shipment date is there. LC is otherwise in order. The beneficiary presented some documents. The bank found the documents complying with the LC terms and made the payment to the negotiating bank. Importer now claims the goods were actually shipped on 5th of April. Hence, the LC was not compiled with and refuses to reimburse the bank. Like importers claims the goods were actually shipped on 5th of April. But LC is not compliant, refuses to reimburse the bank. Does the bank have to check the actual physical shipment of goods? What is the principle under UCP 600 about documents versus goods? Is the importer stand valid under UCP DC rules? Can the bank legally demand reimbursement from the importer? What precautions should an importer take in such cases? So let's solve this question one by one. Bank does not require to check the actual shipment. As per the UCP DC 600, banks deal with documents only. This thing is clear. Make sure this thing is clear to you, that banks have to only deal with documents, not with the goods, not with the services, not with the performance, not with the quality. And Article 5 is saying in UCPDC 600, banks deals with the documents, not with the goods, services and the performance. So bank must check whether the documents appear to comply or not. Is the importer stance valid? No, because bill of lading date on 31st of March, then the bank have to basically which phase meets the LC condition. But if board date is there, that shipment is done on 31st March, the bank have to accept it. Any dispute about actual shipment is outside the bank's responsibility. Can the bank demand reimbursement? Obviously, yes. Why? Once the bank found the documents are okay, following the rules, the applicant must reimburse the bank. Okay, because the dispute about actual shipment is between the buyer and seller, not the buyer and bank. What are the precautions? Here, appoint trusted inspection agent, use reputable shipping lines in insurance companies. If anything is suspicious, ask for the inspection certificate and include strict documentary evidence to protect against any type of backdating. So these are the precautions should be taken in the condition of the in these types of conditions. Got it? Okay. Okay. Let's see this one. This one, uh, I think this is same. Okay, not same. Now ABC Bank is there who open an import LC on 2nd of July 2013 on the behalf of its importer client. LC was sent to the advising bank abroad for advising to the overseas supplier. On 2nd of August 2021, the importer complained that the supplier never received the LC. In that case, ABC Bank checked with the advising bank. Advising bank admit that they failed to advise the LC in time. They were only now advising it to the beneficiary. Now supplier is now refusing to ship the goods at the original place. He demand give more money due to price changes and delays. The importer claims that ABC Bank is responsible for the delay and one must compensate for the additional cost. Now in that case, who is responsible for delay in advising the LC, the opening bank or the advising bank? The advising bank. Under the UCP 600, Article 9, an advising bank role is only to check the authenticity of the credit and they have to advise to the beneficiary. Opening bank did send the LC on time, but advising bank admitted they did not advise it to the beneficiary on time because in this case the fault is of advising bank. What is the role of advising bank under the UCPDC 600? Advising bank basically advises a credit, right? Advising bank does not undertake any repayment responsibility. Their job is just to inform the beneficiary the shipment can proceed according to the LC terms. Is ABC Bank liable for the advising bank delay? No. No. Why? Because advising bank act as the agent of the beneficiary, not of the opening bank. So any delay by the advising bank is not the opening bank default. Importer here argue that the ABC Bank should have chosen a more reliable advising bank. This can be commercial or relationship issue but not a liability under the UCPDC. What should the importer do now? Negotiate directly. Negotiate directly with the supplier. This is the only thing left. Now in that case, the supplier demands more money, which is a matter between the buyer and seller. Importer wants the goods. They have to agree for the new price or they have importer should renegotiate the terms, refuse and claim the breach of contract. What is the lessons are there for the opening bank? Only use reputable advising banks who have a good track record, confirms receipt and advising with the advising bank, keep the importer informed if delay occur, maintain clear communication to protect the client relationship. So under UCP 600, the opening bank is not responsible for the advising bank delay. But good operational practice is vital to prevent the client dissatisfaction. Bank are deals with the documents only. They are not responsible for any type of disputes between the buyer and the seller. Got it? So these are the questions for today. I hope that it helps. If any problem is there, so kindly tell me in the comment section so I can help you out. So that is it from my side for today. Let's meet in our next class with some more questions and some more case studies. We will learn every case study in numerical every day. So thank you. Let's meet in our next class. Till then, take care everyone and have a good day all. Thank you.